I remember the exact moment I stopped being afraid of them. It wasn't when my son-in-law, Miles, told me I was confused about how equity works, in front of 3 attorneys and a court reporter. It wasn't when my daughter, Savannah, sat across from me at the mediation table and wouldn't meet my eyes. It wasn't even when Miles slid a printout across the table. A single page, our family bakery's last annual revenue statement with the number circled in red pen, $127,000. Like he was showing me something embarrassing. Like he was proving a point about how small my life had always been. It was the moment right after that, when my attorney, a woman named Carol Briggs who had practiced business law in Phoenix for 26 years, and who had never once in our 8 months of working together raised her voice above a conversational register, set down her pen, looked at that circled number and smiled. Not at Miles. Not at his attorney. Just at the number, like it had reminded her of something she'd been looking forward to saying. I watched Miles register that smile. I watched something shift behind his eyes, just slightly, the way confidence shifts when it meets something it didn't prepare for. My name is Judith Hale. I am 54 years old. I live in Scottsdale, Arizona, and I have made bread by hand since I was 9 years old, standing on a step stool in my mother's kitchen. And this is the story of the morning my daughter and her husband walked into a room, believing they had already taken everything from me, and found out that the thing they thought they were taking had never been theirs to reach for. Let me tell you about what this all looked like from the outside. A bakery in Old Town Scottsdale called Hale and Hearty. My grandmother started it in 1971 as a bread counter inside a natural foods co-op, just a folding table and a hand-lettered sign, and her sourdough starter, which she'd been maintaining since 1963, and which she brought with her in a mason jar from her kitchen in Flagstaff. By the time my mother inherited the business, it had grown into a real storefront on 5th Avenue with 6 employees, a rotating seasonal menu, and a reputation for a specific kind of honey wheat loaf that people drove in from Tempe and Chandler to buy on Saturday mornings. I took it over when I was 31. My mother had a stroke that came fast and left her with significant limitations. And someone had to step in, and I was the one who had always known how everything worked. Not because I had a business degree, I didn't. Not because I had planned to run a bakery, I hadn't exactly. But because I had spent my whole life in that kitchen, and I understood, at a level that was almost physical, the difference between a business that holds and a business that drifts. What I did over the next 20 years was not glamorous. It was 4 a.m. alarm clocks, and flour on every surface and a 12-year renegotiation with our wholesale supplier that ended with terms my mother would never have believed were possible. It was a catering extension that I built from scratch, starting with one corporate account, and grew until it was contributing nearly 40% of annual revenue. It was a second location I opened in 2019 in Tempe. Modest, careful, profitable within 14 months. It was a proprietary spice blend I developed for our holiday breads that we began selling retail in 2021 and which was, by the time any of this legal unpleasantness began, licensed to 3 specialty grocery chains in the Southwest and pending with a 4th. Nobody knew about the licensing deal except Carol and my accountant, a meticulous man named Gerald Fitch, who had been doing my books since 2009, and who communicated primarily through annotated spreadsheets and the occasional approving nod. I didn't hide it. I just hadn't announced it. There had been nothing to announce yet. Contracts were still being finalized. The timing, as it turned out, was something close to perfect. Now, Savannah, I want to be fair here because this is my story, but she is still my daughter, and some things are genuinely complicated. She was 30 when she married Miles Rutherford. He had come to Arizona from Atlanta for a commercial real estate position with a firm that developed mixed-use properties, the kind of projects that turned old neighborhoods into curated experiences, with artisanal coffee shops on the ground floor and 2-bedroom units starting at $200 a month. He was charming in the way that certain men are charming, effortlessly, without appearing to try, which is often less a natural gift than a practiced discipline. Savannah had worked with me at the bakery through her 20s. She had genuine talent, particularly with the front of house, with customers, with the particular warmth that makes people want to come back. I thought, and I think I was right about this for a long time, that she loved the work. What I didn't fully understand until much later was that Miles had been talking to her about the bakery in a specific way for several years. Framing it, the word he apparently used often was asset. Not a family business. Not a legacy, an asset. And assets in Miles's understanding of the world were things that existed to be leveraged. The plan, as I came to understand it through what emerged in discovery, was this. They would encourage me to bring Savannah on as a formal co-owner. Something I had been intending to do anyway as part of a gradual transition. Once she held ownership interest, they would use that position to argue that the business decisions I had been making unilaterally, the catering division, the Tempe location, the licensing agreements, had diluted her stake without her consent. They would claim mismanagement. They would use the threat of a formal dispute to pressure me into a buyout structure that transferred effective control to them at a price that reflected none of the business's actual current value, let alone its trajectory. It was, in its way, sophisticated. Miles understood commercial real estate law. He understood how to structure a deal that looked reasonable from one angle and was a trap from another. He had underestimated two things. The first was Carol Briggs. The second was the fact that I had been quietly building something for 20 years and I had learned, the hard way, to protect what I built. The mediation was held at a conference suite in a building in downtown Phoenix, 11 stories up with a view of the mountains to the east, that on a clear December morning looks like something from a painting. The kind of room that has been designed to feel neutral but actually feels like money, clean lines, no clutter, filtered light. The particular silence of a place where significant things are regularly decided. Savannah and Miles were already seated when I arrived. She was wearing a blazer I didn't recognize, dark green structured. Her hair was back. She looked like she was dressed for a job interview, or a closing. Miles had on a charcoal suit with a pocket square, which I mention only because he had never worn a pocket square to a single family event in the 6 years I had known him. And the pocket square told me everything I needed to know about how he was thinking about this room. Like a performance. Like a deal he had already made in his head. Their attorney was a man named Barrett Finch, a business litigator with a specialty in closely held company disputes, who had a confidence in the room that I recognized immediately as the specific confidence of someone who has won this kind of case before by sheer pressure. By making the other side feel small. By making the numbers sound insurmountable and the alternative sound worse. Carol and I sat across from them. Carol had a blue accordion folder in front of her, elastic banded shut, which she set on the table without opening. The session began. Barrett made his opening, something careful about unilateral decision-making in a co-owned enterprise, and remedies for breach of fiduciary obligation. Language that was technically accurate and strategically framed to make it sound like I had been stealing from my own daughter. Carol listened without expression. She did not write anything down. Then Miles reached into the leather portfolio in front of him. I think he had been waiting for this moment. I think it was important to him, specifically, that there be a moment. He pulled out a single sheet of paper, the revenue printout, and he slid it across the table to the center. The way you slide something when you want everyone at the table to see it. When you want the act of sliding to carry its own message. We're not here to be unreasonable, he said, and his voice had the particular warmth of someone being very deliberate about sounding warm. But let's be clear about what we're actually talking about. He tapped the number, $127,000, the net revenue figure from 2 years ago, before the Tempe location had hit its stride. Before the licensing royalties had begun flowing. This is what this business generates. Judith, we want you to be comfortable. We want you to have what you need. But Savannah has a stake in this company and that stake has been managed in ways she didn't agree to. And we think the fair thing, the kind thing, is to let us take over the operational responsibility so you can rest. So you can rest. I was 54 years old. I had been up since 4 that morning because I always get up at 4. Not out of obligation anymore but out of habit, so deep it lives in my body. I had driven myself to this building. I was sitting in this chair with 23 years of decisions behind me. And he was offering me rest like I was someone's elderly aunt who had gotten confused about her own affairs. Savannah had not looked at me since I sat down. Carol let the silence sit for a moment. Then she said, to no one in particular, is there anything else before I respond? Barrett said that covered the preliminary position. Carol reached into the accordion folder, not the whole folder. Just one tab, the one marked with a small yellow sticker I hadn't seen her place there. She pulled out a single page, set it in front of her, and glanced at it briefly. Then she looked up. "Mr. Finch," she said, "I want to make sure festesis of your client's claim before I introduce some materials that may be relevant. Your position is that my client made unilateral business decisions affecting a co-owned entity without consent. Is that the core of it?" Barrett confirmed that was correct. And those decisions include, specifically, the expansion of the catering division, the opening of the Tempe location, and, she paused here, and the pause was not accidental, any licensing activity related to the company's proprietary products? Barrett said yes. Those were the areas of concern. Carol nodded slowly. The way you nod when someone has just confirmed something useful. I ask because the framing of that claim depends on a specific premise, that Savannah Rutherford holds co-ownership interest in Hale and Hearty Bakery, LLC, at the time those decisions were made. She picked up the page in front of her, held it for a moment. She does not. The room did something strange. It didn't get louder. It got quieter, but the quality of the quiet changed. The way a room changes when a structural thing shifts and the air moves differently. Barrett leaned forward immediately. That's a significant assertion. It's a documented one, Carol said. She opened the accordion folder fully now and began placing documents on the table, one at a time, with the patience of someone who has organized these in a very specific order, and intends for each one to land before the next is introduced. Here is what was in that folder. When Savannah had come to me 3 years ago and we had begun discussing a formal transition of partial ownership, we had started the process. We had talked about it. We had engaged a business attorney, not Carol, a general practice attorney who did estate work primarily, to begin drafting documents. And then, in the middle of that process, Miles had become involved in those conversations in a way that made me uncomfortable. Not anything I could point to directly. A tone. A set of questions about the licensing revenue potential, which at the time I hadn't publicly discussed with anyone, that suggested he had been looking at our financials more carefully than I had realized. A suggestion, offered casually over dinner, that a formal ownership transfer might be structured in a way that gave Savannah operational authority, rather than just equity. I had not at the time understood exactly what that distinction was meant to accomplish. But something in my chest had said, wait, and I had listened to that. I had called Carol. I had explained what was happening. She had listened to the whole thing without interrupting, and then she had said very quietly, "Don't sign anything yet." The ownership transfer documents had never been finalized. Savannah had been operating in an informal capacity. She had a letter of intent, a preliminary framework, nothing that had been executed, nothing that had been filed. Hale and Hearty Bakery LLC remained, at the time of the mediation, and at the time of every decision they were claiming I had made unilaterally, entirely and solely my company. Your client's ownership interest claim, Carol said, setting the last document down, is based on documents that were drafted but never executed, never filed, and were explicitly placed on hold pending further review. A hold that was communicated in writing to the attorney who prepared them. She looked at Barrett directly. That attorney is copied on correspondence in tab 3. Your client was aware the transfer had not been finalized. She signed no ownership documents because none exist to sign. Barrett was reading. He was reading the way I imagine people read when they are looking for the thing that makes this not true. When they are scanning for the exit in a room that is very slowly not having one. Miles had stopped looking at the documents. He was looking at Savannah. Savannah was looking at the table. There is one additional matter, Carol said, and her voice had not changed at all, same register, same pace. She pulled a second group of documents from a different tab. The proprietary spice blend referenced in my client's catering and retail products, marketed under the trade name Hale's Harvest Blend, was trademarked in my client's name individually in 2020, prior to any discussions about a formal ownership transition. That trademark, and the licensing agreements currently associated with it, are the personal intellectual property of Judith Hale. They are not assets of the LLC. They are not subject to any co-ownership claim, present or future. The licensing revenue derived from those agreements flows to my client as an individual. not to the business entity. She set that document on top of the others. The 3 active licensing agreements currently generate approximately $84,000 annually in royalty income. A 4th agreement is pending execution, with a projected annual royalty of $31,000. These figures are documented and verifiable. She folded her hands on the table. The revenue figure your client presented as representative of this business's value is, to put it plainly, approximately 2 years out of date and does not include the personal IP income stream at all. The actual picture is considerably different. Barrett asked for a recess. Carol said, "Of course, take whatever time you need." During the recess, I sat in the hallway with a cup of coffee from the credenza by the elevators, and I looked at the mountains through the floor-to-ceiling windows. And I thought about my grandmother's sourdough starter, the one she brought from Flagstaff in a mason jar. The one that was still alive in my refrigerator at home. That I fed every Sunday without fail. 61 years old and still working, there is something, I have always thought, about things that are tended carefully over long periods of time. They outlast almost everything else. Miles came out into the hallway at some point during the recess. He stood near the elevators for a moment. He didn't approach me. He didn't say anything. He looked like a man recalculating something complicated and finding that the numbers no longer worked the way he had arranged them. The mediation concluded that afternoon. I won't detail every element. Some of the settlement terms are confidential, and I have no desire to perform any of this beyond what is actually useful to say. What I will tell you is what mattered. The attempted claim of co-ownership was withdrawn. There was no basis for it. There never had been. The biz transition conversations were formally acknowledged as preliminary and non-binding. The catering division, the Tempe location, the licensing agreements. Every decision I had made in the preceding years was documented, defensible, and mine. The licensing IP was affirmed as my personal asset. The 4th grocery chain agreement was executed 6 weeks after the mediation, right on schedule. Savannah and I did not speak that day after the session ended. She left with Miles without looking back. I heard later, through my younger sister who had remained close with Savannah, that they separated 8 months after the mediation. Not a dramatic falling out. The separation was filed quietly. Miles apparently relocated to Atlanta. Whether the failure of the plan had anything to do with the failure of the marriage I genuinely do not know. And I have tried not to speculate. Because that is a thing that still hurts in a way I don't have clean language for. Savannah called me on a Tuesday morning in October, about 11 months after the mediation. I was in the Tempe kitchen, and I almost didn't answer because my hands were in dough and I had to wipe them on my apron and find the phone on the counter. She didn't explain anything at first. She just said, "Mom, I'm sorry." And then she was quiet for a while, and I was quiet too. And the dough was getting cold on the counter, but I didn't put the phone down. We are not all the way back. I want to be honest about that. Some things, once they have happened, leave a texture and you can smooth it down, but you can feel it under your hand when you press. We talk now. We had lunch last month at a place she chose in Tempe, not far from the 2nd location. And she ordered the honey wheat toast and ate it without commenting on it, which is how I knew she remembered. She is living in Scottsdale again. She is doing well, I think. I hope she is doing well. The bakery is not small anymore. Not the way Miles meant when he circled that number in red. The Tempe location was ranked in the top 10 specialty bakeries in Maricopa County last spring by a regional food publication that I still have on my refrigerator, not because I need the validation, but because my grandmother would have gotten a kick out of it. We are in conversations about a 3rd location. I am taking my time. The licensing deal with the 4th grocery chain closed on a Thursday. I was at the 5th Avenue location when Gerald called me with the final number. I thanked him and I went back to the counter, and I finished packaging the morning's loaves. Nobody in the bakery knew anything had happened. Which is exactly the way I have always preferred to work. Here is the thing about being underestimated when you're over 50, and I want to say this plainly, because I think it is true, and I think it is worth saying. People see a certain age, a certain kind of business, a certain kind of woman, who gets up at 4 in the morning, and doesn't talk about herself at dinner parties, and they write a story about her. They decide what she has, and what she doesn't have, and what she understands, and what has gone over her head. They write the ending before they sit down at the table. Miles had written his ending before he ever picked out that pocket square. What he didn't account for was the work that happened before the room. The 23 years of early mornings. The supplier negotiations that took a decade. The attorney I had called on a gut feeling. Because something in my chest said wait. The trademark I had filed in my own name because Carol had told me, very quietly over cough 3 years earlier, that a woman in my position should own her own creations clearly and completely, not as a matter of distrust, but as a matter of clarity. He saw a bakery with 127,000 on the bottom line, and he thought he understood what he was looking at. He was wrong about what the number meant. He was wrong about what I had built underneath it. And he was wrong, most fundamentally, about who he was in that room with. Carol sent me a note afterward. Handwritten, on her firm's stationery. It said, "The best prepared client I have worked with in 26 years. Don't let anyone circle your numbers for you. I have it in a frame in my office, next to a photo of my grandmother's bread counter from 1971. A folding table, a hand letter sign. A mason jar with a starter that is still alive, today. Some things, if you tend them right, outlast almost everything that tries to diminish them. I want to ask you something before you go, and I mean this genuinely. Has someone ever looked at what you've built and decided they understood its value better than you did? And were they right? Or did they find out, eventually, that they had only been looking at the surface of something that went much deeper than they realized? I want to know. Tell me in the comments. I read every single one. And if this story stayed with you, you know what to do. Subscribe to Mara Payback. A new story every day.